Just play right there.
And if you need to call Sheldon or somebody to come down, just text them and tell them we need it right now. Cause numbers 23 DCCR 0448, 0449, and 0450 on Stephen Hayes. Mr. Cobb. I just realized on this Kelly, when I signed it, I didn't put the year, but it's already been scanned. Have the file stamped. Good morning. Are you Stephen Hayes?
Sure.
And Mr. Hayes is charged in each of his cases with sexual assault of a child. And Mr. Cobb, what is the announcement?
Right now, Your Honor, we still need to get the rest of the discovery. We should be able to get that done in 2 weeks.
Okay,
I'm going to try to see if I can ask for 2 weeks. We were going to try to see about getting a bond reduction. I tried to get a hold of Miss Tatiana yesterday. The problem is I didn't realize that she had a case for trial.
yeah.
So
Did
I
you
need
file
to-
a motion for bond?
Not yet.
Okay,
The reason
well, I'll
why,
take that.
because we needed to get the affidavits on. He lives in Caldwell County.
Here's what I'll do. I don't take up any bond issues unless something's filed so that the district attorney's office has a time to be prepared for that hearing.
Right.
As soon as you get something filed, we'll get it set as quickly as possible.
I was going to try to get an agreement.
Okay, if you have an agreement, then y'all can
Not
send
yet,
that to me
no.
and I'll take care of it that way. If not, we'll have a hearing on it as soon as it gets filed.
Yes, ma'am.
All right, thank you. You can go back with the bailiff. We're just gonna do a normal reset though.
Right. Okay, thank you.
Yes, sir.
I'll get everything done as soon as possible.
Okay, thank you. Mr. Burbank on Reginald Guillory. Start there first. Just try to restart it first. Yes, they did. Good morning. I have some thoughts on this. That I might try to help with. Good morning. Are you Reginald Guillory? And so Mr. Guillory's case is set for pretrial today and trial to begin next week. After it was set because of the new system, we don't see when someone has a vacation letter in. Mr. Burbank has filed the vacation letter. And so we're trying to figure out a better way, obviously, with the new system to make sure that we don't set things on those dates. But that's part of our, that's part of what we're trying to figure out. So I'm going to reset the case. Mr. Guillory, I'll reset it for as quickly as I can on another docket so that we can get your case tried as quickly as possible. But because we have a vacation letter, we're going to go ahead and get that moved off of next week's trial docket. All right. Thank you, Mr. Burbank. Thank you, Mr. Coleman.
Was, yeah.
Okay. Mr. Burbank? Did he go back? That's okay. Just give him a minute. Mr. Galmore? Mr. Levine or Levine? Mr. Nix? Mr. Paget? Thank you. Okay. Ms. Perazzo on Florencio Gillen, cause number 23, DCCR 0324.
Judge, can we hold that?
Yes,
This
we'll
is a
hold.
continuation of on here and I have an officer come over.
I will hold it. Thank you. Ms. Perazzo on Kalen Johnson, cause number 40181. If you'll hold that too. Mr. Radford, are you ready on Joseph Freeman?
Bargain rejection letters.
Did you do it through the tablet or?
No.
That's fine. Perfect. Joseph Freeman, cause number 38728, 39679, 40981, and 23 DCCR 0100.
That's the 10.
Have y'all not talked about this yet?
I talked to him at the jail.
Okay.
Have the rejection papers.
They're on the tablet at the jail. Thank you. All right, so you're Joseph Freeman.
Yes, ma'am.
Mr. Freeman, and cause number 38728, you're charged with a third-degree felony offense of deadly conduct from October 22nd of 2021. And what that means is if you go to trial in that case and you're found guilty, the range of punishment is between 2 years and up to 10 years in the institutional division of the Texas Department of Corrections. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 39679, you're charged with a first-degree felony offense of aggravated robbery from March 19th of 2022. And in that case, what that means is if you go to trial and are found guilty, the range of punishment is minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In cause number 40981, you're also charged with the first degree felony offense of aggravated robbery from March 19th of 2022. And again, the punishment range, if you're found guilty in that case, is between 5 years and up to 99 years or life in prison. Do you understand? And then finally, in cause number 23, DCCR 0100, you're charged with the first degree felony offense of murder from March 27th of 2022. That carries that same punishment range of between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have in all of these cases some plea bargain rejections that you've signed with Mr. Radford that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases to a 10-year term in the deadly conduct, a 50-year term in the other 3 cases that would all run concurrently with each other, which means together at the same time. You have every right to reject those offers, have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
All right, we'll get them set on the trial docket. As far as you know, Mr. Radford, have you received all of the discovery?
I haven't gotten the media yet.
Okay. Do you anticipate that that would, I typically want all of the discovery done before I place it on the trial docket in case it changes
It's
some?
not gonna change anything.
Okay,
You can put it on the top, but I haven't got the media. I dropped off. They needed a big disc and I dropped one off, but I haven't gotten notified that it's been done.
okay.
Can you
Other-
check on that?
I'll happen.
Yeah, just make sure you get that. If it does change anything, once you get it, I would want to know well before that trial
Yes, ma'am.
date. All right, you can go back with the bailiff. Thank you, sir. And then Amanda Hurstman,
She's in custody.
cause number 39253 and 23 DCCR 0585. What'd you say?
She's in custody.
They all are today.
Did you get a haircut?
No, it fell out.
Oh,
Yes, sir.
I just saw Johnny. I asked him if he'd ever talked to, he
Mhm.
said no, he hasn't.
I'll
So,
make the call today.
good.
Because I don't have another 14,000 things on my plate today. I feel like I need to stop and start over having a day. Good morning. Are you Amanda Hurstman?
Yes, ma'am.
And Ms. Hurstman is charged with the state jail felony offenses of fraudulent use of identifying information and possession of a controlled substance, penalty group 1. Mr. Bradford, what is the announcement?
Judge, the fraudulent information case, we appeared on about a month ago. I requested the watch guard videos from the police officers. I need those to show Ms. Hurstman. I have not received those. It's my understanding that Mr. Coleman has requested those from the police and
Okay,
he has not received.
okay,
That is correct, Judge, and I'm prepared to dispose of that fraudulent use of identifying information. My method of disposition, I'm sure, is not opposed by defense counsel, but she has the other case, the possession.
She just got indicted on that.
yeah, it looks like it was just a,
I need to get the media on that.
okay.
And I have requested those.
Sounds good. Sounds like y'all are working towards a resolution. I'll go ahead and reset it for 30 days and we'll get the media on the new case. And that sounds like that might resolve things possibly.
Hopefully. Yes,
All
ma'am.
right, thank you. Yes, sir. Thank you, Mr. Radford. Mr. Samuel, on Jalen Lewis, are you working on paperwork on that one? Yeah, I just might need to hold it for a minute because my tablet's not working, so they're coming down to fix it. So if you're doing paperwork, I won't be able to receive it yet.
Okay, we do need to do paperwork, or we want to move forward with MTRP.
Okay, and there's an agreement on that one?
No, but we're working on
Okay, all right, I'll just hold them then for a minute while you do that paperwork.
it.
Thank you. Mr. Wilkerson, on Isaiah Fuentes, cause number 41415.
Morning,
Morning, are you Isaiah Fuentes? And Mr. Fuentes was previously in court, entered a plea of guilty to the second-degree felony offense of aggravated assault. The agreement in that case was to go on count one only, as well as a 15-year cap. I received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes.
Yes, Your Honor, we have.
Are there any additions or corrections?
None from the defense.
No corrections from the state judge. I did note, Mr. Lesniak and I discussed his comments that almost clouded this as a self-defense claim, but I think is more of an explanation than asserting a defense. And we'd ask court to go forward today.
Okay, Mr. Wilkerson, you may proceed.
All right. I called my client, Mr. Fuentes. briefly.
All right, Mr. Fuentes, raise your right hand for me the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Mr. Fuentes, when you were asked to provide a description of your version of events in this case, you related to the precinct's investigation probation officer that you have been defending yourself. Can you explain to the court just briefly what you meant by that?
That it was two people that charged me up, and they only put in one in my indictment, but it actually was two persons that jumped me.
When
I was
you
just defending myself.
when you say you were just defending yourself, you also have seen a video of what took place in the course of your anger, correct?
Yes.
And you understand and acknowledge to the court that you went past self-defense into the commission of this offense in your actions. Is that correct?
Yes.
And today, are you asking the court to consider your plea in this offense and asking the court for leniency with regard to sentencing?
Yes, sir.
Passed away. Sean.
Any questions of the witness?
I have no questions for him, Your Honor.
All right, any other witnesses?
No, Your Honor, I just wanted to briefly explain that that aspect of the pre-sentence investigation. And I would note that that aspect is the singular difference between the instant offense and the other offenses that are listed in Mr. Fuentes' pre-sentence investigation. That this did start out as a situation where Mr. Fuentes kind of walked into it over a female, and then it escalated to what included the instant offense, Your Honor. Mr. Fuentes, while his history, his misdemeanor history, obviously the court's had an opportunity to review the PSI. I would note that 4 of the offenses occurring prior to 2000, the misdemeanor offenses were related to alcohol, and 2 of them related to driver's license issues. And so while Mr. Fuentes does have a history of offense that involves violence, in this particular instance, that temperament was allowed to take over in his defending himself, but he has pled to the court, and indeed in his PSI he notes that the victim in this case had been deported. And so given his history, he's had advice from any number of lawyers over the course of the years, and yet he still entered a plea in this case, knowing that fact as well, Judge. And so we had asked the court for something at the lower end of the sentencing range. If the court were so inclined, the court does have the deferred adjudication option available to it, such that if Mr. Fuentes was to violate, then the full range of punishment would be available to the court if the court would consider putting him on its first tolerance caseload, and having the opportunity to demonstrate to the court that he has changed his behavior in the recent years, Judge.
All right, thank you, Mr. Wilkerson. Mr. Nichols?
Judge, this marks his 4th conviction for aggravated assault. On top of having a deadly weapon in penal institution, which was his most recent offense, felony offense. So given that, and given the severity of the beating involved in this case, I think 15 is appropriate.
Was this caught on video?
Yes, Your Honor, I have it right here. Would you like to see it?
I would love to see it. I think that would help me, because if it's I think there's, yeah, I need to see it.
I would note that the video only shows one of the individuals involved in this.
Is it very long?
I don't believe so.
No.
Judge, what I'll do is I'll hand the laptop to the court, so you can just hit play. I don't know, maybe you can angle it so Mr. Wilkes can see as well.
You've seen
I've
it.
seen it, yes, and so has my client.
Thank you.
That's a cell phone video taken by somebody at the scene.
Anything else?
Not from stages.
Nothing for me to finish.
All right, Mr. Fuentes, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Your history and the assaultive part of your history is what gives me the most concern, that this is your third felony aggravated assault. You went to prison for 12 years before for aggravated assault. I think there's 20 I don't know, misdemeanors, 15 misdemeanors, several assaults there. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you a trial court certification, shows this was an agreement that I followed, and so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor. May I please?
Yes, sir. Thank you, Mr. Wilkerson. Just let, if you want to make a list, kind of what Ian will do is just kind of get a sticky and he'll hold it up and they'll bring him in. And I can, as I call them too, if I call them on here, if y'all want to get the files here of the ones that are ready. Yes. That way I know and I can grab them, and then you can just do it real quick as I bring them in. It's probably the easiest. Okay, perfect. Thank you. Mr. Burbank, are you ready on Markeith Morgan now? Where's Mr.? Oh, I thought he was just here. Is he in the back? Burbank? Okay, then I'll just hold. And Mr. Levine, are you ready on Matthew Bowman?
If you could put us on hold, I'm waiting to talk to Tommy. There's a couple people in line in front of me.
Okay.
Thank you.
I'm gonna need to take a break. Mr. Lewis, Zende Johnson, clause number 33437. It's right here, Kelly, in my pile. It's in this. Morning. Good morning. Yeah, I just told them I need to go back and get a better attitude. Start over. Zende Johnson. Huh?
Fell off the curb walking in, if that makes any.
Oh, no, did you really? Oh, no. Like all the way? All, did you? It's,
I'm not supposed to just get in the car and go back home.
just start all over. This one shouldn't need a thumbprint because it's an MTRP, right, Kim?
Yes.
Thank you. All right, ma'am, you are Zende Johnson,
Yes.
and will your client waive the formal reading of the motion?
She does, yes.
Ms. Johnson, in cause number 33437, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 25th of 2020 for the offense of aggravated assault, and that was a 10-year deferred probation. Is that correct?
Yes.
Alleges that you violated your probation. Count one alleges that you committed the new offense of theft with previous theft convictions, April 13th of 2023. And is that true or not true?
Not true.
Count two alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count three alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
True.
I'm sorry. Was that true or not true? Anger management. Count four alleges that you're behind in your court assessed fees as of May 9th of 2023 in the amount of $1,989. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yes.
And because those counts are actually true.
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
So it looks like your agreement is that I cannot sentence you to more than 8 years in prison. So as long as I don't give you more than 8 years, you're giving up any right to appeal. I can give you 8 years. I can give you less. It'll depend on the information that is brought to me and what I hear when we come back for sentencing. The district attorney's office will have the opportunity, if they want, to put on evidence of that new offense. And then I would either find it true or not true. And then I'll get a pre-sentence report done. Mr. Lewis will present information to me and I'll make a decision. Do you understand?
Yes.
Okay. And so you understand as you look like you don't understand something. What do you not understand?
I kept, in talking with her, I always said PSI when you're saying pre-sentence investigation. I was letting her know that's what we.
Okay. So the probation department's going to do a report for me, just like they did when you first got probation. But it's going to give me more information about how you've been doing on probation, more information about that kind of stuff, so that I can tell what all you've been doing, good or bad, while you're on probation. Does that make sense?
Yes.
Okay.
And Judge, if I may, I believe the PSI was waived the first time, so that's why she was kind of lost on that. So we may have to have one.
On an aggravated assault?
She said she didn't do one the first time.
I'm sure we did. We probably did something differently where they did it over the,
I think I went to the office and stuff.
what? Yeah,
Okay.
Okay, yeah.
Yeah, she was thinking.
It's required. So I'm sure we did something.
Okay,
I have a short, but there's one in.
Yeah.
okay.
Mr. Parker, Mr. Galmore, thank you. If y'all are talking to your clients or if you're talking to the DAs, that's fine, but the rest I kind of need, there's too much going on right now. So state tenders number 1,
No objections. Judge.
it's admitted. Is there any evidence that Ms. Johnson is not competent? All right, then I'm going to find, Ms. Johnson, that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report. Again, we'll get any information that you think is important, get that to Mr. Lewis. He'll present it to me on your behalf when we come back. And then Ms. Malfino, if you anticipate evidence with regard to that new case, if you'll let us know fairly quickly so that we can set it for a time that we have a little extra time for a witness or two on
I
a
will,
case like
Judge. I'll
that.
pull it for Mr. Smith today and let the court.
Okay, thank you. All right, you can go back to the bailiff.
Okay.
I don't think we need her fingerprints. We don't need Johnson's fingerprints. No, it's MTRP. Thank you.
This is here.
Okay,
You go forward.
Ms. Brazos in the back. Okay. Would you grab Ms. Barrazo, and we need, sorry, what is it? Florencio Gillen, cause number 23 DCCR 0324. Is that it? All right, sir, you are Florencio Gillen, and,
Judge, Mr. Payne is here, I think. to-
yes, okay. Good morning, Ms. Cepeda. Would you please raise your right hand? You swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God. Thank you. And do y'all think it's fine like this, or do we need to
I
use?
think it's okay like this, Judge. To remind the court, we started this hearing last week. We, I guess, took a recess because you wanted to get some more information about the facts of the case from a police detective.
And you had put on some information already about ability to pay and things like that. I already heard that. Okay. So, Mr. Nichols, you may call your witness,
State calls Heather Wilson, Your Honor.
right? And Ms. Cepeda, would you mind stepping on that side of Mr. Gillen, and you can translate for him as we're going. And we'll just go slow so that she can translate. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Detective, would you give the court your full name and your employment, please?
Heather Wilson. I work for the Beaumont Police Department as a detective.
And you work for crimes against persons?
We've got to let her.
I'm sorry. And did you work and are you familiar with a murder case that occurred in the city of Beaumont, February 27th, 2023, involving a suspect named Florencio Gillen and a victim by the name of Gerardo Ramos?
Yes.
The victim is Gerardo Ramos. And could you describe for the court the nature of the homicide? What happened?
It was a pretty brutal and violent scene when we showed up and saw the victim who was deceased and had multiple lacerations to his head and body, very bloody and gruesome looking. Which we had through the investigation found out that he was killed with a machete.
That was a lot, but you can just kind of summarize what.
And then your review of the scene and the evidence and pictures of the body, was it evident to you that there was defensive wounds on Mr. Ramos's hands and forearms?
Yes, that's correct.
And in addition to all the damage to his face?
Correct.
And did Mr. Florencio Gillen or Guillen agree to speak with Beaumont detectives about what had happened?
Yes.
And were those conversations conducted in Spanish, translated by I believe Sergeant Tamayo?
Correct.
And during these conversations, was there any indication that Mr. Ramos had been the aggressor or had attacked Mr. Guillen?
Your Honor, I'm going to object to your say, if Sergeant Tamayo is not here to testify, I would object to any statements that were made outside the courtroom. That's your say.
I think for purposes of this bond hearing, Judge, this is appropriate. If she was present when it was going on, it's just being spoken through a translator.
Overruled.
Go ahead.
You can answer.
Correct. That he did not allege that Mr. Ramos had attacked him.
And isn't it true that the extent of what he claimed was that Mr. Ramos had made statements to him that made him uncomfortable or worried? But there was no attack on him first.
Correct.
It's, yeah, okay. To make, and he's not being asked. Okay.
And how long have you been a police officer?
15 years.
How many homicides do you think you've worked?
Probably been on the scene. It's 100.
You ever seen anything like this?
This was a first.
The court's been furnished, the first part of this hearing with some pictures of the deceased. Have you ever seen another person intentionally do that to him?
I have not.
I'll pass away.
All right, any questions?
Yes, Your Honor. Officer, did you or did your department have any prior dealings with Gerardo Ramos prior to this incident?
I believe the department did. He had received like a trespass warning from a nearby trailer park across the street from where this incident occurred. I personally had not, but patrol officers did.
So you're not aware that he had been trespass warned from the actual trailer park where he was found murdered at?
He wasn't murdered at a trailer park.
I'm sorry, at the location where he was murdered.
No.
Okay. Other than being trespass warned, were there any other incidents involving Gerardo Ramos? Any prior criminal history?
I'd have to look at it. I'm not sure. I can't say offhand.
Okay. Did you know how long Mr. Ramos had been in the country?
I don't know.
Had you spoken to any of the neighbors of Mr. Guillen to determine if they knew Mr. Ramos?
There were no neighbors. It was just them two on the property.
Okay, what about coworkers of Mr. Guillen?
We did speak to some coworkers. I personally didn't, but my supervisor and other detectives did.
Okay, so you're not aware of whether or not the coworkers of Mr. Guillen had any interactions or prior interactions with Mr. Ramos? I am so sorry. Oh my goodness.
I forgot to, sorry.
I'm sorry. Okay.
había tenido alguna interacciones con los empleados, digamos, no sabe, quería saber si vamos a tener algún archivos de vehículos en el pasado, que sea cuando ya has pasado la propiedad, donde tenían dicho en el pasado, donde también fue, no fue la propiedad que era pasado y que tampoco no hubo no fue la parte hecho en cerca sino que fue separado. Y que ella sabe de otros tratos criminales que ha hecho, vamos no sabía compartir los archivos. Entonces, le hace saber que se puede que ella sabe de Gerardo Ramos y de conocerse.
I'm so sorry. Okay. Officer, so you testified that Mr. Guillen had made statements to some of the other officers about him being worried about what Mr. Ramos was doing before he attacked him, correct?
In our interview with myself and Sergeant Tamayo, he expressed that Mr. Ramos had asked him to kill him, and he was afraid that if he didn't, it would be harm to him.
Do you translate?
Say that one time. Ramos was the one that asked to be killed.
That's what he claims,
That's
yes.
what he said. Okay. Dice que le han dado con usted y que usted le ha dicho que Ramos había dicho que él quería que usted lo matara. Y si no, claro, si no fuera la otra manera que usted lo matara. Entonces,
It's just,
Okay. Officer, one last thing. Did Mr. Guillen tell you that he was afraid of Mr. Ramos or worried that he was going to do something?
After that statement of once Ramos had asked him to kill him, he expressed something along the lines of, if he didn't kill him, he felt like harm would be done to him. So
la pregunta es que sí, que habían hecho antes que se tenía temor, que si usted no matara, vamos a ir a matar a ti, porque lo que había dicho.
I have no further questions.
anything else?
I have a couple of questions for Mr. Gillen, Your Honor, that I don't think were covered before that I cleared up.
Okay.
Mr. Gillen, are you a United States citizen?
Yo tiene la ciudadanía de los Estados Unidos, señor. He's resident.
And what is your citizenship?
¿Y cuál es la ciudadanía de su propia situación?
La ciudadanía.
La ciudadanía, ¿cuál es? The citizenship for the United States.
Well,
or this country?
are you a citizen of another country?
Tiene la ciudadanía de otro país.
No.
Do you have a passport?
Tienes un pasaporte.
What country passport do you have?
¿De qué país fue que consiguió ese pasaporte?
Es de aquí, no residente
No,
de-
he's answering. He's
No,
saying,
de-
I got the passport from the residence, but that's not what you want.
No,
Do you have a US passport?
¿Tú tienes un pasaporte de los Estados Unidos?
no nomás de residente, pues es pasaporte para venir de México.
I got he says, I got the residence so that I could come back from Mexico. So the passport, I believe, is from Mexico.
Es residente, es por estar aquí. ¿No?
Como el residente?
Sí.
Yeah, the residence is so he could be here in the United States.
All right, thank you. Another question, Judge.
Anything else?
No, Your Honor, not at this time.
Thank you, Detective. All right, any other witness
No other witnesses, Your Honor.
on either side?
No, Your Honor.
All right, Mr. Guillen, at this time, I am going to deny the motion to reduce your bond. Based on the evidence that I've heard with regard to the underlying facts of the case and the other factors with regard to the safety of the community, ability to pay, and the fact that you are not a US citizen as well. I'll set this for an announcement and we'll see where we can get if we need to get it set for trial after that.
Yes, Your Honor.
All right, and just be sure you have a notation now for interpreter for announcements and everything, right? Okay, you can go back with the bailiff. Thank you, Ms. Cepeda. Mr. Galmore? Mr. Nix? Cause number 23 DCCR 0455 on Anthony Johnson. It's a sentencing. Anthony Johnson, Mr. Nichols, it's you. Is today the 18th? That's what I've been writing. It just got confused. Good morning. Are you Anthony Johnson? Mr. Johnson was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. I have received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And not from the state judge.
All right, any reason not to go forward with sentencing?
No, Your Honor.
I have no reason, Your Honor.
All right, Mr. Johnson, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings for a period of 10 years and place you on probation. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity today for you. Obviously, you understand, I think, based on the nature of everything that's going on in your case and what you were doing and who you were around, where it can land you, right? If you are successful on this probation, then at the end, the case is actually dismissed. You will never have a felony conviction on your record. And for you and for the underlying facts of this case, that's a huge opportunity. You're young. How old are you? 19. If you are convicted of a felony, it will change your life in a negative way in so many ways. You won't be able to live certain places. Obviously, you won't be able to get jobs. Just lots of things would be very bad. So this is why this is such a good opportunity. The other side to that, so if you violate your probation in any way and you're brought back in here, you could be looking at being convicted of the offense and I could send you to prison for the rest of your life, anywhere from 5 years up to the rest of your life. And I would go back and look at the underlying offense and what the nature of that was and what your involvement was. And it is likely if you violate that you're not going to get just a little bit of time in prison. So you need to change whoever you're hanging around with, whatever you're doing, this is your opportunity to just change it all and live a great normal life like the rest of us. Okay. You will be placed on a high medium risk caseload at first. That's going to give you an opportunity to hopefully do better. You're going to have more supervision at first to make sure you're going down the right track. There are going to be some classes you have to take, some things like that. You are to have no contact with Joseph Seymour at all. That's obviously it's not in person because he's in prison.
He is, yeah, he's been since 27.
That's what I thought. And so, but that's even through any kind of letters, contacting him in prison, anything like that. Never have contact with him again, ever, right? There was something else I was going to say.
And Mr. Dyer, Judge.
That's the big
There was a surviving victim from the robbery.
Yes. Okay.
No
And then
contact.
also a Robert Dyer. Absolutely no contact or communication with the victim. Do you understand? Okay. And do you have your high school diploma?
No, Your Honor.
You're going to get your GED and you're going to start that within 30 days. That is very important to me. And it should be very important to you because it's going to help you get a better job and do better on your probation. It's just kind of a trickle down effect, right? You're going to have trouble on probation if you don't have your education. So it's very important to me. That is a condition of your probation. I want you to get started on that within 30 days. Okay. So I am handing you the trial court certification. It shows this was an agreement that I followed, and so you've waived any right to appeal. And probation will talk to you probably before you leave today. The first thing you do when you're released is go to probation. They'll tell you what you need to do. Good luck to you. Clause numbers 40578, 41434, and 41435 are called on Kendrick Banks. Kendrick Banks. So I see paperwork on one.
The other two are state jail offenses, Your Honor. I'll
They're gonna be
dismiss.
dismissed.
Okay, gotcha. Thank you. Morning, Mr. Rose.
Good morning.
Three murders.
I feel like, yeah. And are we going on count one only?
Yes, sure.
Are you Kendrick Banks? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will.
Mr. Banks, in cause number 40578, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from August 6th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And my understanding of your agreement is that you've reached with the district attorney is that you're leaving your punishment up to me, and it's not to exceed a cap of 7 years in the institutional division of the Texas Department of Corrections, with dismissals in cause numbers 41434 and 41435. Is that your understanding?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report, and we'll come back at a later date for sentencing. If there's anything you think is important for me to know, be sure and get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Cause number 40282 on Cynthia Campbell. Mr. Parker. Good morning. Are you Cynthia Campbell?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Yes, ma'am.
Ms. Campbell, in cause number 40282, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 12th of 2022 for aggravated assault, and that was a 10-year deferred probation. Is that correct?
Yes, Your Honor.
And it alleges you violated your probation. Count 1 alleges that you failed to report to the probation office as directed April 20th and May 9th of 2023. And is that true or not true?
Yes, Your Honor.
True or not true?
Oh, true.
Count 2 alleges that you failed to never become intoxicated, and that on March 27th of 2023, you tested positive for methamphetamines, amphetamines, and tetrahydrocannabinol. And is that true or not true?
True, Your Honor. Judge, may we abandon 3 and 5?
3 and 5.
Yes.
State abandons 3 and 5. Count 4 alleges that you failed to provide verification of performing the, of performing the community services directed. Is that true or not true?
That's true, Your Honor.
Did you enter your pleas of true to counts 1, 2, and 4 freely and voluntarily?
Yes, Your Honor.
And because those are actually true.
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
You understand if I follow this agreement, you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
And my understanding is you have agreed that I would continue you on probation, but order that you enter and successfully complete the safety program. Is that
Yes.
correct?
Yes, Your Honor, and I do greatly appreciate giving me some help in rehabilitation, because that is what I need. I need to get off the streets and I need to get off these drugs.
Good. Well, that's what we're going to give you the opportunity to do. And if you're successful in safety, you'll get out of safety. You'll be in some aftercare. You're going to have all the tools that you have at that point to be successful. So it's very important that you take advantage of this opportunity.
Sure.
You know that if you don't and you come back again, you could be sentenced to prison for up to 20 years, right?
Yes, Your Honor.
All right. So I'm going to find that you entered your state tenders number
No
1.
objection.
It's admitted. Is there any evidence that Ms. Campbell's not competent?
No, Your Honor.
I need the waiver. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the agreement, continue you on probation in order that you enter and successfully complete the safety program. And so I've handed you a copy of the trial court certification that shows this was an agreement that I followed, so you don't have any right to appeal. Good luck to you.
It doesn't matter. That doesn't say it's 1, 2, and 4, not 1, 2, and 3.
1, 2, and 4.
It's okay. Thank you
And I
so
think
much.
you also wrote safe Q instead of safe P.
Well, they looked that way.
And that's why
It's supposed to be a
it
P.
threw me off. I was like, is this a new program?
It's a new
We've got
program
safe
that I
Q
didn't
instead of
say.
safe P. Maybe it was just the handwriting. Good luck.
Thank
You
Your
can
Honor.
go back.
Thank you.
You're welcome. They're not done yet. Those, or I would have asked for them. They're the ones that just need to go in the file. Okay, yes, I got it. They're reset for sentencing. I was gonna lean over and say that at some point. I forgot. Goodness gracious. This is good, though. This Mervyn stuff. Okay. At least she was pleasant. Amanda Clowers, cause number 37626. Mr. Rojas. Good morning. Are you Amanda Clowers?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
Sure.
Ms. Clowers, in cause number 37626, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 6th of 2022 for the offense of unauthorized use of a motor vehicle. That was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
True.
And it alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department as directed September 6th, November 14th, and October, in the month of October of 2022. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 4 alleges that you failed to provide verification of participating in the education program for your GED. Is that true or not true?
True.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. And is that true or not true?
True.
Count 6 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Count 7 alleges that you failed to successfully complete the JCDI program. Is that true or not true?
True.
Count 8 alleges that you failed to successfully complete the safety program. Is that true or not true?
True.
There was an offer, if the court's inclined to accept it for 18 months in state jail. I don't know how many more counts you would think necessary, whatever.
So the cases that are listed in that first amended part from San Augustine, have those all been taken care of?
I don't think she's got a hold on it. She's gonna go back to San Luis and take care of all that stuff. She also has cases, a case in Hardin County. That was prior to this, prior to the motion.
I'm not aware that Mr. Smith has spoken to either of those counties, Your Honor.
Okay. So does the state want to abandon the rest?
It may help them just if we could
I agree.
just recite at least 10 and 11, Judge, or 9,
9, 10, 11.
Yes, sorry.
Count 9 alleges, Ms. Clowers, that you committed the new offense of possession of a controlled substance in San Augustine County, April 15th of 2023. True or not true?
True.
Count 10 alleges that you committed the new offense of forgery of a government or national instrument on April 20th of 2023 in San Augustine County. Is that true or not true?
True.
Count 11 alleges that you committed the offense of failure to identify a fugitive or false information on April 20th of 2023 in San Augustine County. Is that true or not true? All right, we'll abandon 12, 13, 14, and 15.
Thank you, Judge, and I will contact San Augustine. Let them know.
Thank you. Did you enter your pleas of true to counts 1 through 11 freely and voluntarily?
Yes, ma'am.
And because all of those counts are actually true.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence Ms. Clowers is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. At this time, I'm going to revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I know part of your agreement is that this will run concurrently with your other cases. If this case happens first, it's really probably up to the other counties. It's fine with me if it runs at the same time,
Yes,
but it
ma'am.
will depend on what happens in those counties because they haven't sentenced you yet or you haven't reached agreements. Do you
Yes,
understand?
ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, ma'am. You can go back with the bailiff.
Yes, ma'am.
Clause numbers 23 DCCR 0398 and 0399 are called on Destiny Marshall. Mr. Parker. Good morning. Are you Destiny Marshall?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Excuse me, yes, Your Honor.
Ms. Marshall, in cause number 23 DCCR 0399, you're charged with the state jail felony offense of theft of property with 2 or more previous convictions from December 26th of 2022. The indictment alleges you were previously convicted of theft July 17th of 2015, and then again, May 12th of 2022. And how do you plead to that charge?
Guilty.
And are those 2 prior offenses true?
Yes.
Are you entering your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence Ms. Marshall's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of property with 2 or more previous convictions, sentence you in accordance with your agreement to a term of 13 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to sign the dismissal as part of that agreement in cause number 23, DCCR 0398. I'm handing you trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am.
One thing I told her I'd bring to the court's attention, and she is concerned about getting credit for her back time. I told her she'd get credit for any time that she's been in jail in this case.
Mhm.
And she was out of county with a hold on her here, and the jail only shows 46 days. I told her she will get credit for any time.
If you had a hold from our jurisdiction, you will get credit. Where were you?
So I started here January 6th, and then I left on the 18th, and then y'all picked up the accusations on January 22nd. I was in Chambers County until June 1st. I came back here. So I've been incarcerated from January 6th.
So if you
But y'all
were,
picked up I got rearranged on January 22nd in Chambers County for these charges.
can you just make a note on it to double check the Chambers County to make sure that,
And then they transported me back here on June 1st.
Okay.
Whenever I was finished there.
so it's just showing the June 1st till
It's
now.
showing from June 1st to
Gotcha.
now. Yes, ma'am.
Okay, we'll make a notation of that. We'll double check the Chambers County for sure.
Thank you.
Yes, ma'am. Good luck to you. Cause numbers 23 DCCR 0036 and 0056 are called on Matthew Bowman. Mr. Levine, is it Levine or Levine?
It's Levine, you got it right.
I think I've said it every way this morning, even when you weren't here when I called your name. So I just happened to get it right this time. And do you have your discovery certification?
Judge, I think this is a rejection.
Oh,
It's a
okay,
rejection.
never mind. Then we're good. I've got them here. I can just pull them up and then I'll print them out. Just remind me to put actually, I'm gonna go ahead and print them. It's not letting me print it. So when I do it, when I send it back, if you'll print it, I just want to make sure y'all put my little stickies on. Good morning, sir. Are you Matthew Bowman? And Mr. Bowman, in cause number 23 DCCR 0036, you're charged with the first-degree felony offense of aggravated assault with a deadly weapon in a dating family or household from January 28th of 2023. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, October 19th of 2009. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, May 5th of 2020. On that same date, another possession of a controlled substance, third-degree felony. And on that same date, an aggravated assault, family violence, second-degree felony. What that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand? In cause number 23 DCCR 0056, you're charged with the third-degree felony offense of possession of unlawful possession of a firearm by a felon from January 28th of 2023. That indictment alleges those same prior offenses, which again means if you're found guilty in this case, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand that as well? I have here on the computer some plea bargain rejection that you've signed with Mr. Levine that shows that the district attorney's office has made an offer. And is it the same in each case?
It's the same in each case, Judge, and I would like to point out that our offer was originally the minimum of 25. However, Mr. Levine negotiated a abandonment. We agreed a one-time today only offer of abandoning one of the punishment enhancement paragraphs and offer of 15. So that offer today, 15 was a one-time today only offer.
All right. So, Mr. Bowman, I want to make sure you understand what the state's offered and what possible consequences and all that stuff is. So they've offered you today, if you wanted to enter a plea of guilty in your cases, a 15-year term in the institutional division of the Texas Department of Corrections. It looks like in each case, and that would run concurrently. Is that correct?
Correct, and I've explained to him that at a jury trial, if the state did file a motion to stack, those sentences would run consecutively instead of concurrently if they chose to do that.
Are they the same date?
Yes,
Are they
it's the same
eligible
training.
for
It's the
consecutive?
same
I don't think they could run consecutive, actually.
Okay.
So, so no matter what happened, I don't believe that they could run consecutive. They would run concurrently, which means together at the same time, whether it's the 15 years or whether you're found guilty and the jury sentences you on each case. Do you understand? You have every right to reject this offer. I want to make sure, and I am going to make a notation on these so that they're in the file, that this offer is on the table today. After today, Mr. Coleman has said, and I won't accept any plea offer that would be 15 years or less. Do you understand? If you changed your mind and wanted to plea later, it'd either be to whatever he offered or it would be open to the court. You understand all of that? And do you want to reject these offers and have your cases set for trial?
Yes, ma'am.
Okay. And Mr. Levine, as far as you know, have you received all the discovery?
Correct.
Anything that you're waiting on that we need to know about?
No, Judge.
Okay, so Mr. Bowman, I'm going to reset your case on the trial docket. Mr. Levine will begin preparation for trial.
And the other thing I was gonna ask you as well is Mr. Bowman did want me to ask you for a bond reduction today. He has.
So here's the thing, what I'll do is if you filed a motion for a bond reduction, that'll give the state time to prepare for that. I'll get it set as quickly as possible and we'll come back for a bond hearing.
Yes, ma'am.
Okay, thank you. You can go back with the bailiff. Make sure if you have any vacation or anything that you filed a vacation letter. And if you haven't, file one now and make sure you CC her because our system's having some issues as getting notification of that. So make sure that Kelly has that information.
I will do that.
Okay, thank you.
Okay.
But just CC her on
I'll
it.
do that.
We're having some issues.
Thank you. Appreciate it.
Thank you, Mr. Levine.
Thank you, guys.
Let's see, did I send both of them? Yeah, I did. So y'all can print those out and put my little stickies on them, please. Clause numbers 40707, 40708, and 41010 called on Eric Smith. Mr. Parker. If there's anybody that has something ready that's not my people, I'll take care of those if you'll double check.
You know, all these new discovery printouts, you can't tell what cases.
It goes to,
I mean, they don't have a number on there. That's fine.
is this all one thing?
That's two different cases. That's, yeah, that's two different cases.
Gotcha.
And I think it's the right order, but
That's fine. And so is,
no case can be dismissed.
And one is a plea to count one, Judge, and one is a plea to count 1 and 2. So we
Okay.
have to do those seconds.
figure that out. So 41010 is the one to be dismissed, correct? Okay. All right, are you Eric Smith? And Mr. Parker, will your client waive the formal reading of the indictment in each case? Let's see, so in 40707, what count in that? That's the assault on a peace officer.
Let's count one now.
The state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer from August 6th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
In cause number 40708, going on count
One and two.
One and two?
It's also the second.
the state's elected to proceed on count 1 and 2. Count 1 alleges you committed the new offense, third-degree felony offense of unlawful possession of a firearm by a felon from April 10th of 2022. Count 2 alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1999. And how do you plead to that charge?
Guilty.
And is that prior offense true?
Yes, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And my understanding of the agreement that you've reached in each of these cases is that you're leaving your punishment up to me, but it's a cap of 12 years in the institutional division of the Texas Department of Corrections, which means if I follow the agreement, I cannot give you more than 12 years.
Yes, ma'am.
I could give you 12 years. I could give you less. We'll come back at a later date for sentencing after I'll get a pre-sentence report done from probation. Mr. Parker can present any information on your behalf as well as the state, and then I will make my decision. You have every right to have a jury come in and determine 2 things. One, if you're guilty or not, and then you could leave your punishment up to them. By going forward this way, you're waiving that. And is that what you want to do?
Yes, ma'am.
Right. Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And also, just so that the record's clear, part of this agreement and plea bargain is that there will be a dismissal in cause number 41010. You understand that as well?
Yes, ma'am.
State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty, but I'm going to again reset your case so that we can get that pre-sentence report done, and we'll come back at a later date for sentencing.
Yes, ma'am.
All right, I'll see you at sentencing. Thank you, sir. You can go back with the bailiff. Yes, ma'am. Uh-huh. Okay. She does. No, she just usually does it and then hands them to me in the file. And so I have the written one already. It's fine, however you want to do them. If they're already here, I have some that are already here. Okay, I'll do them. Cause number 40474 on Jamie Ashby. Oh. He is in trial. Does he have paperwork? Do you have paperwork?
I'll show you how to operate the tablet, Judge.
Okay, I'll go, if you'll just put it on top. Good morning. Are you Jamie Ashby? And speak up, please, ma'am. And Mr. Gilmore, will your client waive the formal reading of the indictment?
Sure.
And are we going on all of the counts?
Well, I think we only need count 1 and 2, unless I looked at the indictment wrong. Count
Just-
2 is a felony.
It's a state jail, so we need at least 2 to do something.
One makes it a third, I think, right? One prior.
Not on a state
TDC.
jail. You have to have 2.
Yeah.
2 makes it a second.
What makes it third?
One does nothing.
Okay.
So it's either a second or it's nothing.
Just a second.
If it's two state jails, it makes it a third. Two real felonies make it a second. One real felony does nothing. So I'm just gonna make that, I'll make that admonishment, but if with your permission, I'll change that on the admonishment sheet. Is that okay with you?
Because it doesn't change the outcome.
It is, okay, perfect. So Ms. Ashby, in cause number 40474, you're charged with the state jail felony offense of theft and aggregation amounts from January 1st of 2021, continuing through February 18th of 2022. The indictment alleges you were previously convicted of theft, a third-degree felony, July 20th of 2007, in two different cases on that date. And then after those were final, you were convicted of theft, a first-degree felony, on November 5th of 2012, making this a second-degree felony offense for punishment purposes. And how do you plead to that charge? Speak up. And are those prior offenses true? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Any evidence Ms. Ashby is not competent? All right, Ms. Ashby, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you are mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of felony theft. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. Shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Galmore. Good luck to you, ma'am. You can go back with the bailiff. Hey, Kim, this one did not have your, yeah, I need that, Dustin. If you'll hand it to me, I'll sign it first, and then you'll email the, thank you, sir. Thank you. Okay, and did I just, her name's not on one of those Kim's now. I just put a sticky, but I didn't write on the sticky what it meant. Mr. Burbank, cause numbers 23 DCCR 0697 and cause number 39658 are called on Markeith Morgan.
And Your Honor, at the conclusion of sentencing, I have a couple of family members that are going to be making a victim impact statement.
Okay, so 39658 is re-indicted.
697, Your Honor.
Okay, that one should have already been
Yes,
dismissed.
it should.
All right, sir, are you Markeith Morgan?
Yes, ma'am.
And Mr. Burbank, will your client waive the formal reading of the indictment?
Well, yeah.
Mr. Morgan, in cause number 23 DCCR 0697, you're charged with the second-degree felony offense of robbery from August 6th of 2020. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
Objections?
It's admitted. Is there any evidence Mr. Morgan is not competent?
No,
And any reason not to go forward with sentencing today?
no, Your Honor.
All right, Mr. Morgan, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you are mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery. Sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Your Honor, if I may address one issue.
Yes, sir.
I wanted to make sure that he would get credit, which is an understanding between the state and I for the murder charge. This was a plea bargain.
If it was re-indicted, it should be, it'll follow it because it was a re-indictment. So anytime, I mean, these were the same charges out of the same, I mean, it's the same incident. It was just a new charge, and so it'll show up on the computer that it was re-indicted, and we'll make a notation of that as well.
Thank you.
And that's your understanding.
That is, Your Honor.
All right, I need the certification. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to your attorney. It's my understanding there's a victim impact statement.
Yes, Your Honor. As you know, this while we're pleading to robbery, this involved a murder that cost the life of Antonio Wilson. His mother would like to address Mr. Morgan, and the mother of his son would like to address him as well. So we have two people giving victim impact statements. this morning.
Any objection to two? All right, so,
You want
Ms.
him to sit in the office?
Yeah, that might be easier. We can just have them, put them, that way we don't have to move all the attorneys. And then let's turn the podium kind of that way. Ken, you didn't sign this one either. And Mr. Nichols,
Yes, Your Honor.
no, go ahead. You can stand right there, ma'am. Good morning to both of you. And this will be off the record. You may proceed.
First, I would like to thank the judge and the court for the opportunity to speak so you can understand my heart. Antonio's son, his siblings, his nephew, who was like his son, his family and his friends, heart is real. And also get a glimpse of a legacy that he really left behind. August 6th, 2020 was the worst day of my life. It changed my life tremendously. My son was horrifically murdered by Marquis and his associates. You have no idea of what you and your friends stole from us. You didn't just take a life, you took my baby. You took my son hero. You took his best friend, his super dad, and one of the world's greatest fathers. My other grandson, Antonio's nephew, you took his role model, someone that loved him dearly. In society today, there are too many children being raised in a single parent home. And unfortunately, my grandson is being raised in a single parent home without his father. He would never know what it's like. His dad was murdered at his age of 2 years old. And all he has is a memory of his dad. And that's it. Antonio was not given the opportunity to raise his son or nephew, to teach them how to be loving, kind, compassionate, in which Antonio was that person. Aubrey has to grow up without anyone to train him, take him to football practice, basketball practice, baseball practice. He would never have the privilege to look out in the audience and say, that's my dad, dude. My dad is here. All because you all decided to rob my son. And a senseless act of crime was committed and his life was taken. You and your friends stole a life that wasn't meant to end this way. God gifted me with Antonio. He was supposed to grow old with children and grandchildren by his side, and he was deprived of that. You all stole that from him. Antonio was a good person to anyone he met. It didn't matter who it was. Whatever you needed, he never met a stranger. If you just asked, he would have given it to you. I don't care what it was. He was kind-hearted, compassionate, loving, and giving. Not only was he known for bringing people together to have good times, he was also an activist in his community that would go out and feed the homeless. Children that were less fortunate, he would do drives and make sure they had the necessary things that they needed for them to be able to go back to school. Be it tennis shoes, backpacks, clothes, haircuts, whatever the case was. He saw to it that those needs were met. I feel robbed. His son has been wronged. He suffers the biggest injustice in this whole situation. Why? He gets to live a life of a memory, of a love for a person that was taken away too soon. On January the 27th, you were arrested by the U.S. Marshals, charged with murder. Bond set at $1 million. You mentioned at the time of your arrest in a sarcastic tone to me that you have a mother too. But I quote you, just tell that man, mama, I'm sorry. I didn't kill that man. But I want to ask you, what were you sorry for? Were you sorry that it took 1 year, 5 months, and 21 days for you to be caught by the U.S. Marshals? When you had the opportunity, because you knew, you sit by and you watched the crime as it took place. You had the opportunity to walk in and give information, and you chose not to. Or are you sorry that now you're the only one that's here today because your friends or associates are still out there and you're the only one here? You're not going down for murder, you're going down for robbery. But you're the only one that's here going down for the crime that was committed on August the 6th of 2022. When my son was gunned down by you and your associates as you and your friends witness, or whatever you want to call them. At that point, my son became evidence and property of the city of Walmart. I did not have the chance or the opportunity to say goodbye to my child as I stood against a wall and was told I couldn't touch him, I couldn't kiss him, I couldn't hug him. Those are things that I would never forget. I would never forget. Your mother, on the other hand, come and visit you, be it a jail cell or a prison cell. Your mom gets to see you. Where do I go? To the grave. I grieve. I still cry. I still have sleepless nights because I know within my heart there are others that are out there that are still committing senseless crimes that has not been brought to justice. So I have no hope. I have none. That day altered our lives. I don't ever want you to forget that. Whatever you do, please never compare me to your mother. There's no comparison. She has a luxury that I will never have. Please understand, your choice in aiding to take my son's life led you to this faith in this moment. Please remember that God is just. So when you make terrible choices, you get even worse results. Society says it's karma. It's not. It's reaping and sowing. I pray within my heart that God touch your heart and that He deals with you, because at the end, He's the ultimate judge. I pray that this time of your incarceration, that you find the Lord, accept Him, and be delivered because you can. Right now, I can't say that I forgive. I'm still hurt. But I want you to know, I'm praying that God will soften my heart and that I will be able to forgive you. And I do pray for you. And all I can say is, may God bless you.
I was telling her I had a statement, but putting it into words on a piece of paper just wouldn't work, because my 5-year-old can't put anything on a piece of paper about how he feels about not having his dad. He's 5 now. But it goes to show you, it was a while ago when it happened, he was 2. And he remembers his dad like he just was with him yesterday. He's that little boy, just like you are. And do you not know how hard it is to be so young and to raise a little boy on my own? And that's the same color as you. I don't have nobody to call if my son gets out of line, gets smart. I have nobody to call if he wants to go play football. I don't even know nothing about sports. I have to do this all on my own with the help of family and friends when they have the time out of their day to do so. The day that we heard about Audrey's dad and the day that we got a call, it was like something came over my son, because the moment I got a call saying he got hurt, my son ran in the house asking for his dad. He ran in the house asking to see his dad that same day, like something that just came over him, and he knew, Mom, I want to talk to my dad, like call my dad. We didn't get to see the body, we didn't get to talk. We didn't get to say anything. It was just like he was gone. He didn't even have the opportunity to say bye. He couldn't say anything to his dad, but he wanted to talk to his dad. That's all he can say. But he can't. There's no phones in heaven. There's phones in jail though, where your mom can talk to you every day. And you of all people probably should know it's kind of hard raising a Black guy in America. I'm pretty sure your mom went through trials, tribulations, and struggles to raise you. So why would you and your friends want to see the next person or have another person go through those same things? And nobody's in here but you. You. Even if you didn't pull the trigger, you were there. You were there. I was gonna cry when I got up there. I cried in my seat. I just knew I was gonna cry, but something came over me to get up there and speak to you because I didn't even want to speak at first. But now you see my face. Now you see Arby Wilson's mom. That's me. Antonio's baby mother who has to raise us on all by herself. And I'm gonna raise him to the best of my abilities. And pray that he never walks down the same road and path that you and your friends took. To be better than you guys, to be better than the next person. And to do better, make better choices, make better decisions. That's what I'll do. That's what I'm taking from all this. That's who I am. So hopefully within your sentence, you do find it in your heart, you know, to explain and to maybe go into details of what happened. And, you know, maybe we will get the justice that we all deserve one of these days. We will, I believe we will, I pray we will. I will. I have no ill intentions towards you. I have nothing evil to say towards you, but that I pray for you. I pray you find peace. I pray you find some type of faith while you're in there. I pray that you find some type of, I pray you find a lot of things while you're in there that one day, you know, you can come forth about what really happened. I do. Because we definitely would like justice. We definitely would. My son would. It can't bring his dad back, but it can bring him some type of peace. It can. It'll definitely bring him some peace. It'll definitely bring his mom some peace. It'll bring us all some peace because this has not been the easiest road for me. I have anxiety. I cry a lot now. My son didn't even want to be around me the same day his dad died because I couldn't breathe. I couldn't move. Imagine a 5-year-old seeing matter of fact, a 2-year-old at the time seeing a mother like that, can't breathe, not understanding what's wrong. And the only other person they're trying to figure out who to call is their dad because something wrong with mom. She crying, she can't breathe, like he couldn't call his dad. He couldn't pick up the phone and say nothing. He couldn't say nothing. He couldn't sit at the front row of his dad's funeral. He can only go to the grave and not allow him to. He couldn't do any of those things. We'll be praying for justice. I'll definitely be praying for you while you're in there. Maybe God will give you some type of change of heart, some type of change of mind, something, and maybe, you know, you will come forward about what really happened to people who were there. And we'll get some justice for all this one day. Thank you.
Thank you all for being here. You can go back with the bailiff. Clause numbers 26660, 40196, and 40197 on Jalen Lewis. Mr. Samuel. So what are we doing on this one?
He's gonna plead true to his MTRP, which is just a state jail, and get it done. And he's rejecting offers in the other cases, and they're gonna be set for trial.
Did you do plea bargain rejections?
Yes.
Oh, okay.
But this at least takes care of that old MTRP that's hanging.
Sir, are you Jalen Lewis?
Yes, ma'am.
Mr. Lewis and Mr. Samuel, in cause numbers 26660, will your client waive the formal reading of the motion? I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 22nd of 2017 for the offense of forgery, and that was a 3-year deferred probation that's been extended, it looks like several times. Is that correct?
Yes, ma'am.
It alleges that you violated your probation.
Your Honor, he's not going to enter pleas on 1 and 2. Those are the 2 pending cases. But
Okay.
our agreement is to enter pleas of true to 3 and 4.
All right, so do you want to just do not true, or do you want to abandon them?
I guess not true. It's fine.
So count 1 alleges that you committed the offense of injury to a child with serious bodily injury, May 31st of 2022. Is that true or not true?
Not true.
Count 2 alleges the same thing, that you committed the offensive injury to a child with serious bodily injury, May 31st of 2022. Is that true or not true?
Not true.
Count 3 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
And count 4 alleges that you are behind in your court assessed fees as of June 2nd, 2022, in the amount of $7,022.52. Is that true or not true?
True.
Did you enter your pleas of true to counts 3 and 4 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1. It's admitted. Is there any evidence that Mr. Lewis is not competent? All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely. 3 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation and find you guilty. And at this time, find you guilty of the offense of forgery. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Samuel.
Yes, ma'am.
Now, in cause number 40196 and 40197, in each of those cases, you're charged with a first-degree felony offense of injury to a child from May 31st of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand the possible range of punishment?
Yes, ma'am.
And I have in front of me a plea bargain rejection that you've signed with Mr. Samuel that shows that the district attorney's office has made an offer, if you wanted to enter a plea in your cases, for a 30-year term in the institutional division of the Texas Department of Corrections, and that would run concurrently. Is that correct? You have every right to reject that offer, have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer in each of your cases and have them both set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. Samuel will begin preparation for trial. All right, thank you, Mr. Samuel. Thank you, Mr. Nichols. Cause number 23 DCCR 0408 called on Kurgan Aller. Mr. Rennick.
Yes, sir.
Morning. Thanks for being patient this morning. Right here, sir. Are you Cargan Aller?
Yes, ma'am.
And Mr. Rennick, will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Aller, in cause number 23 DCCR 0408, you're charged with the state jail felony offense of unauthorized use of a vehicle from October 24th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rennick?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Aller is not competent?
Nothing but defense, Your Honor.
And is this a 1244?
No, Judge.
Okay,
It's a state jail thing.
so it's marked off confinement in county jail for 9 months. It should say state jail.
That's right.
With everyone's permission, I'll make that change on the written agreed punishment recommendation.
Yes, ma'am.
You're okay with that as well?
Yes, Your Honor.
Okay. All right, Mr. Aller, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Oh, I don't think I printed. Did I print? I just sent it to you. Can you print out the admonishment for me on Aller, please? I'm going to hand you. Okay, I'm going to hand you the written admonishment. Excuse me. Going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Rennick. And if you'll step in front of the clerk, they need to get your fingerprints over there, please. Thank you, Mr. Rennick, Mr. Coleman. Cause number 40181 on Kaylin Johnson, Ms. Perazzo. Right, are you Kaylin Johnson? And Mr. Johnson's charged with the first-degree felony offense of murder. And what is the announcement?
So, Your Honor, we have just received a brand new offer that is a pretty decent offer, but I believe that Mr. Coleman needs time to visit with the family members of the deceased to see if that's something that we can work out.
That's correct, Judge.
Okay, can I set it?
And it just be a quick reset. It doesn't have to. be
Well, this
30
was
days.
the last one. So
No,
I'm-
Judge,
That's
I
fine,
feel
I'll give-
confident. I would prefer to.
well, I think you are kind of required to do that. But can you do it this week?
Oh, of course.
Yeah, so we're just gonna reset it to next Monday. If it gets worked out, fine. If not, then it's either a plea to whatever it is, the offer is, or it'll be time to move it to the trial.
Yes.
All right, we'll see you next week.
Thank you.
Cause number 23 DCCR 0527 on Jimmy Taylor. Mr. Lewis?
Jimmy Taylor. Jimmy Taylor.
Huh? I brought some. No.
That was a rejection. I didn't want to tell.
I got it.
Good morning, morning.
Good morning. Right, sir, are you Jimmy Taylor?
Yes, ma'am.
And Mr. Taylor, you're charged with a state jail felony offensive theft with prior theft convictions from December 24th of 2022. Your indictment alleges you were previously convicted of theft February 10th of 1995 and then November 9th of 1995. And then it further alleges you were convicted of attempted burglary of a habitation, a third-degree felony, March 27th of 1998. And after that was final, you were convicted of burglary of a habitation, November 8th of 2004. And what that means is that if you go to trial and you're found guilty, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? I have here on the computer a plea bargain rejection that has your signature on it with Mr. Lewis's that shows that the district attorney's office has made you an offer if you wanted to enter a plea of guilty for a 15-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I'm sorry. Just, hey, listen, just answer my questions, okay? You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And so, Mr. Taylor, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? Okay, so we'll release Mr. Lewis. We'll appoint someone today and they should begin preparation for trial very quickly. All right, thank you.
Thank you, Judge.
Just that I want to look at that. Mr. Lewis on Everett Thompson, cause number 40777. Hang on. Nope, he's not even here.
He's not.
Okay. So, okay, never mind. So that's it for you.
Yes, ma'am.
See, Mr. Parker on Richard Wilson, did we already do that? Is there a Richard Wilson? Should be 2 cases. This is only 1 file. No, this is 1.
One's a new one, one's MPRT. And my staff has faxed over the discovery printout. That
Okay.
should be in office.
Thank you.
Loaded up today, huh?
Like I've been here 12 hours.
Tell me about it.
It's 'cause like
I didn't have to
2
do
of
this
those
week.
3 are
Last week I
very
had 14 people.
not fun to deal with.
I know.
Good morning. Are you Richard Wilson? And Mr. Parker, will your client waive the formal reading of the motion and the indictment?
It was,
Mr. Wilson, in cause number 23 DCCR 0696, You're charged with the second-degree felony offense of burglary of a habitation from May 7th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Speak up.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
You also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. I have to ask everyone that. State tenders number 1.
No objection.
It's admitted. Any evidence Mr. Wilson's not competent. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a habitation. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in clause number 33866, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 25th of 2020 for the offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation in count 1 by committing the new offense of burglary of a habitation, May 7th of 2023. And is that true or not true?
Your Honor, since we have an agreement, I can drop the rest of the counts.
Right.
Okay, report.
State's going to abandon counts 2 through 6. Did you enter your plea of true to count 1 freely and voluntarily? And because it's actually true. I also have paperwork here on the computer in this case that has your signature on them that the state's marked as exhibit number 1. Did you also go over this with Mr. Parker? And do you fully understand them? And do you understand if I follow this agreement that you'll also be waiving any right to appeal? State tenders number 1.
No objection.
It's admitted. Mr. Wilson, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certifications in each case that shows these were agreements that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Yes.
On Mr. Taylor, we just did an objection on, Mr. Coleman just made it. They only offered 10, which I conveyed to him, and he's rejected that as well. But I want to make sure the court was aware that we did get the offer.
Is there- Let me just add. I'm not going to. Can you print out the rejection on Jimmy Taylor for me so I can make a mark on it. Mr. Taylor, it's my understanding that today, Mr. Coleman, the Assistant District Attorney, has made another offer if you wanted to accept it today, but that it won't be on the table after today of a
I'm sorry to
10-year.
interrupt.
Go ahead.
At the request of Mr. Lewis, and Mr. Lewis and I negotiated a 10-year offer.
So Mr. Lewis visited with him again. He's got that offer down to 10 years. Mr. Coleman has agreed to that, and you still can reject that. That's fine. But I want to make sure, and I know Mr. Lewis went over that with you, but that it's on the record that that offer of 10 years is only good for today. And if you reject it, there won't be that offer again. Do you understand? And you want to reject that and move forward with trial. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Coleman and Mr. Lewis. Cause number 23 DCCR 0194 on Joshua Wade, Mr. Rojas.
Joshua Wade.
Oh, I'm running out of words.
Welcome back, Summer.
I know your fingers. Let's see, who's the prosecutor?
Mr. Nichols.
All right, sir, you Joshua Wade, and Mr. Wade's charged with the first-degree felony offense of aggravated assault in a dating family or household with a weapon. There's prior offenses that would make this habitual punishment if found guilty. Mr. Rojas, what is the announcement?
Judge, we have all the discovery. We do have an offer on the case. Mr. Wade has asked me to ask for one more announcement docket so we can try to get in touch with the complaining witness to see what her feelings are about this.
Okay.
And then we'll come back next time and we will have an answer from the court.
All right, so any issues with that, Mr. Nichols?
No, Your Honor.
All right, so Mr. Wade, I'm going to reset the case one more time. This will be the final reset. We'll need to get an announcement at the next court date. All right, you can go back with the bailiff.
Judge, I believe that's everything for me this morning.
Okay.
Every day.
I think it's almost everything for me. We're close. Mr. Rojas on Adele Villafuerte Mora. Cause numbers 23 DCCR 0052, 0053, 0054, and 0055. Did Mr. Coleman leave early? All right, are you Adele Villafuerte Mora?
Yes.
And Mr. Mora, in cause number 0052, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from January 6th of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 10 years in the institutional division of the Texas Department of Corrections. Do you understand the range of punishment?
Yeah.
Cause number 0053, you're charged with the third-degree felony offense of tampering or fabricating with physical evidence with intent to impair from January 6th of 2022. That carries the same punishment range if you're found guilty, which is between 2 years and up to 10 years. Do you understand? Cause number 0054, you're charged with the third-degree felony offense of possession of a controlled substance, penalty group 1, between 1 gram and 4 grams on January 6th of 2022. That is also a third-degree felony offense with a punishment range of between 2 years and up to 10 years. Do you understand?
Yeah.
And then cause number 23 DCCR 0055, you're charged with the first-degree felony offense of assault on a peace officer or judge from January 6th of 2022. If you're found guilty in that case, the minimum punishment is 5 years, up to 99 years or life. Do you understand?
Yeah.
In each of these cases, I have plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has offered in your cases, in the assault on a peace officer case, a 25-year term in prison, and on the other 3, 10-year terms that would all run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yeah.
Do you want to reject those offers and have your cases set for trial?
Yeah.
Okay, we'll set him for trial. And Mr. Rojas, are you appointed?
I am.
Mr. Rojas was appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you? Okay, Mr. Rojas, you're released. Mr. Mora, we'll appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay, you can go back with the bailiff.
Sorry.
It's okay.